named Patrick entered an Alabama prison at the age of 16. In a little more than a year behind bars, he has witnessed more than 30 stabbings. He has learned some lessons. Failing to turn over his property when a prisoner demands it puts him at risk of being stabbed, as does refusing a sexual overture. This thought hangs over him constantly. He is always on guard, ready to fight for his survival. Patrick is one of about 1,200 children under the age of 18 who are being held in adult prisons across the country. This is why we, the Affirmative, support the resolve that the Indiana state government should not be allowed to try minors as adults. For the purpose of this debate, terms will be defined as follows. According to the freedictionary.com, the legal definition of a minor is an infant or person who is under the age of legal competence. In most states, a person is no longer a minor after reaching the age of 18. According to dictionary.com, a juvenile is a young person or youth. Jurisdiction is the right, power, or authority to administer justice by hearing and determining controversies, and waive means to refrain from claiming or give up or forego. Our plan is as follows. Step 1. Institute a law that prevents juvenile courts from waiving the jurisdiction of a juvenile to be tried as an adult. Step 2. Keep juveniles in juvenile facilities. It is not necessary to build additional facilities. Only 10,000 are put in adult prisons nationwide, leaving multiple facilities that are not full. Step 3. Use money that is saved from holding and transferring juveniles to adult facilities to help improve programs in juvenile facilities that help them, such as integrating back into society. Our contentions for this case debate are as follows. Mental health, crime rates, and multiple harms. I will now develop our first contention, mental health. According to the status quo, the juveniles who are tried and convicted as adults are kept in adult prisons, where most mental health stressors can occur. From EJI.org, many young children in America are imperiled by abuse, neglect, domestic and community violence, and poverty. Without effective intervention and help, these children suffer, struggle, and fall into despair and hopelessness. Some young teens cannot manage the emotional, social, and psychological challenges of adolescence and eventually engage in destructive and violent behaviors. Sadly, many states have ignored the crisis and dysfunction that creates child delinquency and have instead subjected kids to further victimization and abuse in the adult criminal justice system. The whole experience of being tried as an adult as a minor is deeply traumatic, and trying and holding juveniles as adults makes the problem worse from a mental standpoint. According to EJI.org, some 10,000 children are housed in adult jails and prisons on any given day in America. Children are 5 times more likely to be sexually assaulted in adult prisons than in juvenile facilities and face increased risk of suicide. This is the kind of environment that we are leaving children in. Adult prisons also don't offer the option of rehab like juvenile prisons do. According to SPLCenter.org, this is terrible for juveniles, as research has also shown that children have a unique propensity for rehabilitation. The human brain is not fully developed until the mid-20s, and the portion of the brain that governs rational decision-making is the last to develop. This means that a child may engage in dangerous behavior without fully realizing the risks and consequences for themselves and others. After presiding over a juvenile court for 14 years, one Florida judge summed up the young people this way. I've been here long enough to understand when someone is 16 and I ask them why they did it, and they say, I don't know, and I believe them. Unfortunately, the adult system fails to recognize the potential for rehabilitation in children. This can be particularly damaging for children without a strong support system of family, friends, and community. My evidence shows that in order to maintain a good mental health, juveniles must be taken out of adult prisons, and by extent, the adult justice system. Our plan can keep these children safe. My opponent may claim that the crimes that these juveniles commit can be particularly heinous and deserve to go to jail in adult prison. But as my evidence has shown, that does not warrant the mental torture of a child. And adult prisons does not provide the rehabilitation resources necessary to allow the child to try to get better. Kids like Patrick are not left mentally well, and as my partner will prove later, are more likely to go commit more crimes when out of prison. It is for these reasons that we, the Affirmative, support the resolve that the Indiana state government should not be allowed to try minors as adults. I am now ready for cross-examination.
Okay, so are the minors committing crimes capable of knowing the severity of their crimes?
Yes, but as my evidence shows, their decision-making processes aren't fully formed.
Is this due to the frontal lobe not being fully formed?
Yes, prefrontal cortex.
Did you say that the age at which the frontal lobe or the prefrontal cortex is fully formed is 20?
No, I read it was fully formed at 25.
25, okay. So people under this age, so people who are not considered minors, ages 18 to 25, their prefrontal cortex is not fully formed. Why are they being tried as adults and not as minors?
Because they are not minors anymore. Because the legal definition of a minor is someone who is under 18.
But if you are focusing on the part of the brain that is developed and that is why the minors are being excused from the adult court, then why is not this other age group being included?
Because they're not minors.
Okay. So if a 17-year-old and an 18-year-old were to commit the same crime, they would be tried differently?
I mean, I guess.
Because according to Fox News, a 17-year-old and an 18-year-old jointly murdered another 17-year-old. Do you think that they should be tried separately just because of a 3-month age difference?
I guess not.
I have no further questions.
According to an article written in the Albuquerque Journal in 2016, Albuquerque teen is getting away with 2 counts of second-degree murder and 3 counts of child abuse resulting in deaths of serious repercussions. In January 2013, the then 15-year-old Nehemiah Griego shot his mother, brother, and 2 sisters with a .22 caliber rifle, and when his father came home, he shot him as well with a different rifle. He was sentenced as a juvenile and only faces a couple years of incarceration in a facility determined by the New Mexico Children, Youth, and Families Department until he turns 21 in 2018. This is why we, the negative, negate the resolve that the Indiana state government should not be allowed to try minors as adults. For the purpose of this debate, terms will be defined as follows. According to Barry Beckman, a professor of neuroscience at Ohio State University, the amygdala is the part of the brain that processes emotions. According to thefreedictionary.com, the legal definition of a minor is an infant or person who is under the age of legal competence, which is 18. An adult is a person who, by virtue of attaining a certain age, generally 18, is regarded in the eyes of the law as being able to manage his or her own affairs. According to medicinenet.com, the frontal lobe is the part of the hemisphere of the brain located behind the forehead that serves to regulate and mediate the higher intellectual functions. The frontal lobes are important for controlling thoughts, reasoning, and behaviors. And according to the National Institute of Justice, recidivism refers to a person's relapse into criminal behavior, often after the person receives sanctions or undergoes intervention from a previous crime. The status quo is as follows. A youth below the age of 18 can be waived jurisdiction in a juvenile court, thus moving them into a adult court. For someone at least 14, at the age of commission, the court may waive jurisdiction if it finds 1, probable cause to believe the child committed an act that is either heinous or aggravated or part of a repetitive pattern of illegal acts. 2, that the child is beyond rehabilitation under the juvenile justice system. And 3, that it is in the best interest of the safety and welfare of the community that the child be tried as adult. The court will waive jurisdiction for a minor of at least 16 years of age if they have been accused of manslaughter, reckless homicide, or any non-drug Class A or Class B felony. And the juvenile court has no jurisdiction over a minor of at least 16 accused of having committed a statutorily excluded offense. And these offenses include, but are not limited to, active and intentional participation in a criminal gang, murder, kidnapping, rape, armed robbery, and dealing in cocaine and other narcotic drugs. And any minor that has committed past felonies or has been waived before will be waived again. Our contentions for this case are as follows. Number 1, already effective. Already effective. Number 2, justice. Justice. Number 3, mental development. Mental development. I will now develop our first contention, already effective. According to a report published by the National Center for Juvenile Justice, quote, juvenile arrests or violent crime have dropped to a 30-year low, and fewer teens are being locked up than any time in nearly 20 years, end quote. The NCJJ goes on to show that juvenile violent crime arrests have dropped by at least 60% since its highest point in 1994. In addition, reports published by the Indiana Department of Correction over the past 5 years shows that the rate of recidivism in juveniles is decreasing. What this means is that the system that is already in place has solvency and that it's doing its job. According to a survey conducted in 2004 by Richard Redding and Elizabeth Fuller and published in the Juvenile and Family Court Journal, only about 21% of juvenile offenders they interviewed knew about the transfer laws, but 75% admit that if they'd known about the laws regarding their trial and sentencing in adult court, they would not have committed the crime. My opponent may claim that incarceration does nothing to reduce crime and recidivism rates, but as my evidence has shown, the rate of juvenile violent crime has been decreasing since the 90s. In addition, my evidence shows that having juvenile transfer laws does have a psychological effect to deter crime. It is for these reasons that I, the negative, negate the resolve that the Indiana state government should not be allowed to try minors as adults. I'm now ready for cross-examination.
So you say these kids, they committed heinous crimes and they deserve to be tried as adults.
Yes.
So you're saying that they should not have a chance to, because adult prison systems don't have an option of rehab. So you're saying that these kids, they don't have a chance to at least try to get better?
No.
Okay, moving on. So at what expense? So I pointed out from my evidence that being held in adult prison is not very good for these kids. And I know you said that the violent crime rates are starting to go down. So at what expense? Because these kids are being mentally scarred, and at what expense does that mean for the crime rate to go down?
Well, kids are only put into prisons and are only given adult sentences for really serious crimes, and these sentences, the punishments would not be as appropriate if they were only given juvenile sentences, and my partner will explain a little more about that later.
Okay. I have no further questions.
According to the Campaign for Youth Justice, about 250,000 minors are tried, sentenced, or incarcerated as adults each year. This is nearly equivalent to the population of Barbados. These minors all face greater danger in adult prisons due to their age. This is why we, the affirmative, support the resolve that the Indiana state government should not be allowed to try minors as adults. I will now develop our second contention, crime rates. Countless studies completed over the course of many years show evidence that trying and convicting youths in adult court actually leads to higher rates of recidivism and repeat offenders. A PBS article even cites evidence from a study dating back to 1996 in which the researchers concluded. The findings suggest that transfer made little difference in deterring youths from reoffending. Adult processing of youths in criminal court actually increases recidivism rather than having any incapacitated effects on crime control and community protection. According to the Center for Disease Control, youths transferred to the adult system are 34% more likely to be rearrested for a felony than if they remained in a juvenile facility. My opponents claim that by transferring these minors to adult court, they might receive a punishment deserving of the crime. However, the following evidence will show that by trying juveniles in adult court, the majority are not receiving punishment for their crimes. Statistics collected by the Campaign for Youth Justice show that 50% of minors tried are not convicted in adult court. Furthermore, less than 1/4 of juvenile convictions in adult court result in a prison sentence. The majority of these minors are not experiencing consequences. Our third contention is multiple harms. The status quo holds physical harms for youths incarcerated in adult prisons. According to a New York Times article written on June 5, 2012, juveniles are 5 times as likely to be sexually assaulted in adult prisons than in juvenile facilities. Furthermore, the numbers could possibly be higher. In another New York Times article written September 18, 2005, the author, who was incarcerated for committing robbery with a toy gun at the age of 17, recounted his own experience of getting drugged and gang raped by a group of older inmates on his first day. He wrote that the Justice Department acknowledged that statistics for rape and sexual assault in prison may actually be much higher than estimated, due to the fact that many prisoners are too scared to come forward. In the article, he goes on to state, quote, "I was too afraid to tell anyone what happened to me because I was convinced my attackers would kill me," end quote. The article also acknowledges that minors who are sexually assaulted in prison are more at risk because HIV rates are estimated to be more than 3 times higher among prisoners than among the general population. The status quo also holds social harms as well. Minors that leave adult prisons are usually faced with suspicion by possible employers and by the rest of the community because they are viewed as more dangerous than minors that are held in juvenile facilities. Juvenile facilities have programs to help induct youths back into their communities. Our plan has inherency because it has advantages that the status quo cannot achieve. It allows minors safety in prison and a better chance of being reintegrated into society as more mentally stable human beings. Because juvenile facilities are designed with youths in mind, they have more access to resources to help with mental health that would be more difficult to find in an adult facility. According to the Division of Youth Services website, IDOC/DYS youth are given treatment interventions that include being placed in juvenile treatment programs, group therapy, and individual counseling and therapy. The number, intensity, and type of interventions for each youth is based upon their level of risk to reoffend and assess criminogenic, mental health, educational, vocational, and aftercare needs. Multiple programs are listed on the website, including, but not limited to, education against substance abuse, readiness and induction, and numerous types of therapy. These programs are targeted towards youth, unlike programs in adult facilities. Furthermore, the plan would allow for minors to be safer from sexual assault because of new programs being instituted. As stated in the attention getter, minors can best be treated in facilities designed for them. It is for these reasons that I, the affirmative, support the resolve that the Indiana state government should not be allowed to try minors as adults. I am now ready for cross-examination.
So if your parents went out and said not to invite any of your friends to your house while they were out, would you do it anyways?
No.
Okay. Well, would you agree that there are people out there who would invite their friends anyways, despite the warning?
Yes.
Well, would you think they would do it if their parents had threatened to ground them for a month for disobeying them?
Maybe not. It depends on the type of person.
But then would you agree that a threat of serious punishment is enough to curb behavior?
Not necessarily, because as I stated before, youths incarcerated in adult facilities are 34% more likely to reoffend with a felony than youth that are held in juvenile facilities.
All right. So, when your birthday comes around, do you ever feel drastically different when you turn?
Sometimes.
All right. How much do you think can mature within several months?
I think people that given the chance can change sometimes within several months if
someone is, say, 17 and a half, would you agree that probably nothing huge changes about them when they turn 18 besides some legal rights?
I wouldn't necessarily agree with that because a few months still allows time for them to mature.
Would you agree that it would not necessarily be enough to completely change how they view the world and their morals and their behaviors?
Maybe not, well, not necessarily, but if they're given the right resources, then they can change, such as the resources that are provided in our facilities. But
My time is gone.
According to the Office of Juvenile Justice and Delinquency Prevention, about 610 murders were committed in 2013 by minors. According to this same source, that is about 1,200 minors who have taken human life in 1 year. This is why we, the negative, negate the result that the Indiana state government should not be allowed to try minors as adults. I will now develop our second contention, justice. According to a recent ABC News poll, 70% of people across the United States believe that the crime, not the perpetrator's age, should be the determining factor in sentencing. According to the Office of Juvenile Justice and Delinquency Prevention, age is taken into account when examining the crime committed by a minor. However, for serious crimes, such as rape, murder, and armed robbery, the factor is lessened and the crime itself takes precedence. According to Gabrielle Hollingsworth, a lawyer, many lawyers and attorneys will actually advise their minor clients to be okay and actually be glad if the judge decides to waive their case to an adult court, because the juvenile justice system restricts some rights in the juvenile court. For example, minors do not have the right to trial by jury in a juvenile court. In adult courts, minors have a fair opportunity, as well as, according to the same source, added empathy from the jury due to the minor's age. According to the Office of Juvenile Justice and Delinquency Prevention, minors are not tried as adults for crimes that do not require severe repercussions. However, when it is, quote, in the best interest of the safety and welfare of the community, end quote, that the child receive these repercussions and be removed temporarily or indefinitely from the community, and after an investigation and a hearing, the judge overseeing the minor's case has the right to waive it to an adult court. So the cases being waived are only those in which the consequences that the juvenile court is allowed to sentence are not enough to act as a consequence for this act of violence. I will now develop our third contention, mental development. According to Mary Beckman, a professor of neuroscience at Ohio State University, the human brain undergoes a burst of gray matter right before puberty near the ages of 11 to 14. This is right before or near the age in which minors can be tried as adults. The burst of gray matter increases a person's impulse control and decision-making capacities to 90% of their total capacities. Also, a study conducted by Abigail Baird and Deborah Jurglin Todd of Harvard Medical School on the part of the brain known as the amygdala in both adolescents and adults concluded that teens' emotional processes are at 95% of their full potential. According to the San Diego Alliance, the human brain, specifically the frontal lobe, is developing throughout adolescence. Because of this, thoughts and or actions that are habituated in effect become wired in the brain. These habits will then continue throughout adulthood because to the human, that is what he or she is programmed to do when certain feelings or situations arise. If we do not prevent, restrict, or detain these habits like the status quo does, these people who exhibit habits of violence will continue to execute the violence. The advantages of the plan outweigh the disadvantages. The threat of our safety is not worth not being able to try minors as adults. We would risk threatening personnel who have comprehended the morality or severity of their actions into our communities, and minors would not be learning the consequences of their actions either. Receiving minimal punishment for violence does not reform or deter offenses. The affirmative plan lacks solvency because their plan does not solve the problem of protecting adolescents. Adolescents need to be taught right from wrong, and the severity of their consequences should correspond with the severity of their action. With the plan in effect, minors will not fully understand the result of their actions, which can affect their later safety, as well as in the present. The affirmatives plan is not workable because it does not provide just nor gradual consequences. In the status quo, the consequences that minors receive due to specific crimes increase with age, so that when a minor turns 18, it is not a major step from one set of consequences to another. It is for these reasons that I, the negative, negate the result. The Indiana state government should not be allowed to try minors as adults. I am now ready for cross-examination.
You said in your constructive that these minors need to be taught right from wrong,
Yes.
correct? So how are they supposed to do that if they're in an adult prison where they have little to no resources in order to teach them what the right thing to do is?
Well, in your plan, you don't have them have the consequence of going to an adult prison, which is much worse than going to a juvenile facility. And so if they think that they can go to this juvenile facility and get out on good behavior or a shorter time period, it is not as great as a consequence as going to the adult prisons.
Well, actually, when minors are incarcerated in adult prisons, 85% of them are released by the age of 21, and 95% of them are released by the age of 25. So are they really receiving enough punishment for their crime?
Well, in the juvenile facilities, there was a boy who was 17 and murdered, raped, and dismembered a child, and he was let out in 5 months for good behavior. And 5 days after he got out, he killed an elderly woman. So in the adult prisons, they would not let you out for 5 months. If
Are you certain
did
of that?
Yes,
Do you have any sources to back that claim up?
yes. The Office of Juvenile Justice and Delinquency Prevention.
Okay. In your constructive, you also said that based on the severity of the crime, the judges in the minor courts would base their judgment more on the. I have no further questions.
According to PBS.org, the juvenile system does work. A 1996 Florida study found that youth transferred to adult prisons had an approximately 30% higher recidivism rate than youth who stayed in the juvenile system. Our plan includes getting more money from holding and transferring juveniles. This money would go towards improving current programs in juvenile facilities designed to integrate back in society. All in all, it is dedicated to making each juvenile into a productive member of society rather than the adult system, which doesn't have any rehab whatsoever, and the mental stressors that are placed on you in adult prison will The status quo lacks inherency. The current system actually has minors being tried as adults, which have all sorts of harms as shown by my partner. The system also costs a lot of money to hold minors in adult facilities, something that the status quo has not addressed. Overall, the status quo cannot fix itself without changing altogether. The status quo also has monetary harm. $569.5 million is the total state cost of prison, and the average annual cost per inmate is $14,823. This, like I said, this is a lot of money that comes from holding and or transferring juveniles to and from adult facilities. And add that together with the actual adults in the facility makes for a lot of money. It is for these reasons that I support the resolve that the Indiana state government should not be allowed to try minors as adults. Please vote affirmative.
The status quo doesn't have inherencies because it reaches the same, if not more, advantages in the affirmative plan. The status quo still has a juvenile system, and yes, it does work. The waiver of jurisdiction only applies to those who have committed serious, heinous, and aggravated crimes. Also, as my partner mentioned, in juvenile court, minors do not have the right to trial by jury. Juries are only present in the adult court, which impacts the verdict of the trial. And in addition, a council of people will likely be much more merciful with their verdict than a single judge. The affirmative plan disadvantages outweigh the advantages because some sentences, different sentences, work with different people. Some respond better to rehabilitation, while others respond better to the threat of harsh treatment. By removing the option of stricter sentences, potential juvenile criminals won't have a serious consequence preventing them from committing violent crimes. The affirmative believes that all juveniles should be given a second chance. However, in my attention getter, Nehemiah Griego had planned for several days on how he would carry out his plan to kill his family. For several days, he had had repetitive thoughts to act as he did. He was also 15 years old, which is older than the ages that my partner said that the brain develops the majority of its decision-making capacity. This means that he was fully aware of his actions when he committed his crimes. The affirmative mentioned that the crime rates are going up, but as I mentioned in my constructive, the threat of serious sentences does have an effect on a person's decision to commit a crime. It is for these reasons that I, negate the resolve that the Indiana state government should not be allowed to try minors as adults. Please vote negative.
According to the National Survey of Youth Custody, 40% of youths are sexually assaulted in correctional facilities, which includes rehabilitation facilities and juvenile facilities. This is approximately 3,200 youth victims on average per year, which is greater than the statistic in which minors are abused in adult jails and prison facilities, as my partner stated. So even with the removal of the trying minors as adults, they will still be abused at a greater rate. There's also the protective custody agreement, in which an inmate can apply for protection from other inmates if they have been assaulted in an adult facility. The affirmatives plan lacks inherency because they will not stop minors from committing crimes. They will only be giving minors an easy way out to escape the severe consequences of their severe actions, which they are fully aware of. Their plan is designed around benefiting minors, but what good is it if minors are taught to think that their severe and or violent actions do not reap equally severe consequences? The status quo is designed to teach minors about and deter them from committing acts of violence. The affirmatives plan has unique social and possibly physical harms, which include letting murderers, rapists, and armed robbers and other legitimate criminals out into our community without serious repercussions. Their plan allows for this to happen, for criminals to continue to break the law and harm society without having understood the severity of their actions. This can cause damage to society as well as individual people that fall victim to the actions of their offenders. My opponent claimed that there are physical harms in the status quo because of the assaults that occur in the adult correctional facilities. However, there is the protective custody agreement, as I have already stated, which prevents people from being abused again. My opponent claimed that the minors are not able to comprehend their decisions or mistakes because the brain is still developing. And while that is true, that the brain is still developing, the brain's impulse control, decision making, and emotional capacities are nearly at their full potential during adolescence. This is why minors only 14 and up are tried for certain as well as extreme crimes. For other crimes, they are not waived to the adult courts and they are kept in the juvenile correction facilities, which is what my opponent is fighting for. The law takes into account that the minor's frontal lobes are not fully formed, and which is why they are not tried as adults in all situations. Only situations in which it is for the best of the community for the offender to be removed. And even then, it is not guaranteed that the minor will be found guilty. They are simply given their right to trial by jury and given a fair chance. And it is for these reasons that I, the negative, negate the resolve that the Indiana state government should not be allowed to try minors as adults. Please vote negative.
Minors under the age of 18 cannot legally drink. They cannot legally vote, but they can be condemned to a lifetime in prison. And in some cases, they can be sentenced to death, since the death sentence is legal in Indiana. Our plan has solvency because it can reduce and solve several problems in the status quo that cannot be fixed with the current standards. It would reduce risks for youths in prison and allow for juveniles to have more resources designed for them. As I stated in my constructive, several programs designed specifically for youths are already in place in juvenile facilities, including rehabilitation and reintroduction into society. Furthermore, rape prevention and elimination programs can be put into place because according to our plan, we would use resources with the money saved from putting minors into adult facilities, and we would put that into programs such as rape prevention and elimination. Our plan can be workable because these programs are already in place in several places, are already being used in several places. However, the status quo has multiple harms. In addition to the physical harms that younger inmates face, such as sexual assault, these younger inmates face social harm when they are reintroduced to society after being released from prison. The negative used an example of a minor who committed murder. However, they did not specify whether he was given any resources in an attempt to rehabilitate him. As a youth who was incarcerated in prison wrote to his local district attorney, "Correct me if I'm wrong, but isn't the purpose of punishing someone not only about them paying for their actions, but also to rehabilitate them so that they don't make the same mistake again? Shouldn't it be the goal of the state for convicted felons to be able to re-enter society as law-abiding citizens and lead productive lives?" It is for these reasons that I, the affirmative, support the resolve that the Indiana state government should not be allowed to try minors as adults. Please vote affirmative.